What is a trademark specimen anyway? A trademark specimen is evidence that you're using your trademark in commerce in a way that identifies the source of goods or services to the consumers. That sounds pretty simple, right? It's not. For goods, which are the physical products, acceptable specimens typically include tags or labels physically attached to the product, packaging or containers showing the mark, point of sale displays, or photographs of the product showing the mark as consumers see it. The key requirement, and this is where it gets tricky, is that the specimen must show the mark as consumers actually encounter it when purchasing the goods. It must function as a source identifier, not just decoration. The distinction seems simple until you're trying to apply it to real-world situations. Take promotional items, like golf balls with your company logo on them, or the custom guitar picks I sometimes hand out as business cards that have my logo on them. It used to be that if you weren't in the business of making and selling the item, it didn't count as a specimen. Recent case law shows courts have been more accepting of this kind of use as a specimen, though. The items are used to build brand awareness, and people often like to use them to show they like the brand, though we often use them just because who doesn't like a free good lip balm or water bottle? Now, whether these things can qualify as specimens of use depends on a variety of factors, so consulting a trademark lawyer is a good idea. Picture this scenario. Someone receives a notice of allowance and submits what seems like clear proof of use: product photos, website screenshots, packaging images. But the USPTO rejects it. They try again with different photos, rejected again. Third attempt, still rejected. This can go on for over a year, with each rejection adding months of delay. The typical problems are product photos that are obviously staged mock-ups rather than real-world use. Website screenshots showing just a homepage with a logo but no products or purchasing mechanism visible. Packaging images that are design proofs rather than photos of actual retail packaging. So what solves this? A photo of the actual product in its actual packaging as it appears on store shelves or in online listings with a Buy Now button visible. Knowing these requirements up front before you launch prevents months or years of delays. Now, for services, specimens are different. Acceptable specimens typically include advertising or marketing materials showing the mark with a description of services, websites showing the mark in connection with the service offering, brochures or promotional materials that clearly indicate the services, signage where services are provided. For services, your specimen must include the mark and a description of what services you provide. A billboard with just your logo won't work. You need text explaining what you do. A business card with just your name and a phone number won't work. You need service descriptions. This requirement trips people up constantly. What works? A website screenshot showing the firm name, a tagline or description of services offered, and ideally a list of specific services. Here's a big myth I need to bust. A website screenshot is always an acceptable trademark specimen, and that's not true, not even close. For goods, your website screenshot must show three things: the mark, the goods, and a way to purchase. For services, your website must show the mark and a description of the services offered. Pretty homepage with just your logo? Rejected. A landing page without clear service descriptions? Rejected. An About Us page? Rejected. Your website specimen needs to show how consumers encounter your mark when they're actually purchasing goods or engaging your services. This is where DIY filers or filers using the cheap online services often get stuck. They submit screenshots that look like they should work, and then they're surprised by the rejection. Let me run through the most common trademark specimen mistakes I see. Mistake 1 is submitting mock-ups or digitally altered images. The USPTO wants real-world use, and they can pretty well tell if it's not. Mistake 2, ornamental use for apparel. This is a big one. It's probably the one that gets made the most often. If you're selling hats, t-shirts, sweatpants, etc. with your logo on the front, back, sleeve, etc., the USPTO usually considers that ornamental and decorative, not a trademark. And again, that's usually. You need the mark on a label, like on the back of the neck, a tag that's maybe attached to the sleeve, or use it in some other non-ornamental way. Now, sometimes having the name or logo on the front of the item does work as a trademark, like the Izod alligator. Yes, I am 1,000 years old. Size, location, dominance, and significance matter, and that's why you should consult a trademark lawyer to see if your use would work that way. But here's a hint, probably not. It doesn't matter if you spent thousands printing t-shirts with large logos on the front. That use will most likely still be rejected as a specimen. You'd have to reprint with the logo on the collar tag or attach sales tags with the logo to every single shirt. Mistake 3, invoices or receipts. They prove you made a sale, but they don't always show how your customers encounter your mark. The USPTO wants to see the mark as it appears to consumers, not on internal business documents. Now, if the receipt or invoice clearly shows the services and the mark, it may be okay. Same for letterhead and business cards. These details make the difference. Mistake 4 is specimens that don't match the goods or services description. So if you applied for, let's say, legal services, your specimen needs to show legal services. If you applied for clothing, your specimen needs to show clothing, not coffee mugs. It sounds obvious, but when businesses evolve or pivot before they file their specimens, mismatches do happen. This is why it's important to make sure the goods and services description is flexible enough to give you a little wiggle room if possible. Don't paint yourself into a corner with a description involving the sale of haunted houses if you might only be able to get a specimen of showing the sale of regular houses. Mistake 5, social media pages and posts are generally not acceptable as specimens for marks used with goods. Social media can be evidence of use for some purposes, but it usually doesn't meet the strict specimen requirements for goods. However, use of the mark in social media that shows the specific services being used in connection with the mark can be acceptable. I've had many client service marks approved using their Facebook or Instagram pages as specimens because the pages had their mark and described the services they were trying to register it in connection with. Every one of these mistakes leads to rejections, delays, and additional costs. Now, let me be really clear about something. I'd like to post a lot of information about the trademark application process. Understanding the trademark process is valuable. It helps you make informed decisions, communicate effectively with your attorney, and appreciate what's involved. But understanding the process doesn't mean you should handle it yourself. Here's a question I get asked all the time. Can I file a trademark application myself and just hire an attorney later if I run into problems? Technically, yes, but this almost always ends up costing more. By the time you hire an attorney to fix the DIY problems, you may have missed critical deadlines, narrowed your protection unnecessarily, created issues that are difficult or impossible to correct, or lost months or years to delays. It's significantly more cost-effective to start with professional guidance than to try to fix DIY mistakes later. Think of it this way. You wouldn't perform surgery on yourself and then call a doctor if something goes wrong. I hope you wouldn't. Trademark law is the same principle. Get it right from the start. Attorney-assisted trademark filing provides comprehensive risk mitigation. Professional searching that identifies conflicts before you invest in branding. Proper goods and services descriptions that protect your business, specimens that will be accepted the first time, deadline management that prevents abandonment, office action responses that preserve your rights, and peace of mind. When you work with an experienced trademark attorney, you're not just paying for time and expertise, you're paying for that comprehensive risk mitigation that protects what may become one of your most valuable business assets. Your brand is one of your most valuable business assets. Protect it properly from the start. Avoid the legal horrors and keep rocking your IP. Ready to file a trademark for your brand? Book a consultation at kingpatentlaw.com. Thanks for listening to Spellbinding IP. I'll see you next week. Here's a quick reminder, this information is for educational purposes only, is not legal advice, and does not form an attorney-client relationship. Now, for advice about your specific situation, consult with a licensed attorney.